G'day, friend. Let's watch some court hearings. Everyone is innocent until proven guilty in a court of law. The commentary and editing provided in our videos are in line with the principles of fair use, as outlined in Section 107 of the United States Copyright Law. So sit back, relax, and enjoy this video. Don't forget to smash the like button, pounce on the subscribe to get our latest content, and comment with the timestamp of your favorite moment.
All right, may I please have your name?
Bob Peterson.
A little louder, sorry, I couldn't hear you.
I'm Bob Peterson.
All right, Mr. Peterson, this is a failure to appear. The underlying case is a possession of drug paraphernalia. Are we going to resolve it?
Yes, Your Honor. There was an adjudication, credit time served, conveyed to Mr. Peterson. I've gone over the plea with him. I just need him to sign.
Let me see. He didn't tell me, so I don't know how much time served he got. Hold on, I gotta get you some prints.
All right, Mr. Peterson, are you under the influence today of any drugs, alcohol, or medication that would impair your thinking?
No, ma'am.
Anybody forcing you to enter into this plea?
No, ma'am.
Do you understand, sir, that if you're not a United States citizen, entering into this plea agreement will subject you to deportation? Yes. Are you currently on probation for any other offense? No, on the charge of possession of drug paraphernalia, how do you plead?
Yeah.
All right, and I did review the original affidavit, and I did find factual basis for the plea. I'll accept your plea of no contest. I'm going to adjudicate you guilty of the offense, and I'm going to give you credit for time served of 17 days. I'm going to assess mandatory court costs and cost of prosecution, which I'll reduce to a civil judgment.
Thank you, Your Honor.
Thank you. May I please have your name? All right, Ms. Lenoci, you've been charged with open container. Are we going to resolve the underlying case?
An offer was not made, Your Honor. Per the face sheet, it says that the defendant has multiple cases in which she has been found incompetent.
Oh, she's previously been found incompetent. I didn't see a suggestion of incompetency in that CF. Was there one?
I was just going by the face sheet, Your Honor.
Not for the CF, Your Honor, just for other cases she has.
No, ma'am, I don't believe we're going to be able to make an offer on your case today. Hold on, I want to look at this CF again.
Can I get PTR in the future, you think? Retrial, because it was just an open, you know.
Oh, slow down.
Yeah. No, we can't give you future. We don't get out of jail cards. Gotta take them one. All right, so in the underlying felony, there has not been a suggestion of incompetency filed. It does look like the Office of the Public Defender was assigned to the defendant. Based on the prior finding of incompetency, I will not take action on it. And on the current case, I'll ROR the defendant. But counsel, what I need you to do is make sure you get with your office and have them meet with the client and assess if there's a good faith belief for it. And if so, to file the suggestion of incompetency in the felony case, and then the notice of related cases in the misdemeanor, and make sure that those travel together and they get addressed.
Okay, thank you, Your Honor.
Thank you. All right, Ms. Lenoci, if you'll just follow the officer out the blue door. May I please have your name, sir?
Rodney DeAndre Harris.
All right, Mr. Harris, this is a failure to appear. The judge did set bond at none. And let me just make sure if you already have counsel in this one. You know, Mr. Ball, is the Office of the Public Defender already appointed? Yes. So you do have the Office of the Public Defender already appointed in your case. Make sure you stay in contact with the attorney, and they'll talk to you about your no bond situation.
Okay.
All right, please follow the officer out the blue door. Please tell me your name, sir.
James.
Mr. James, you've been charged with possession of MDMA. You do qualify for a public defender. I'll appoint the Office of the Public Defender to represent you. I'll find probable cause. I'll stay the bond at $2,500.
Okay.
Please follow the officer out the blue door.
Thank you.
Thank you. May I please have your name, ma'am?
Helen Rosa.
Miss Rosa, you've been charged with criminal mischief. This is a warrant signed by a judge. Probable cause was previously found. I'll appoint the Office of the Public Defender to represent you, and I'll stay the bond at $1,500. And there's additional conditions of release: no return to the scene, and no contact with the victim or witnesses.
Yes, ma'am.
Thank you.
Your Honor.
Yes.
Here you go. Briefly, I was going ahead and notating something for Lanucci for my office as you recommended, but I believe Mr. Quentin James, I believe he has a comp hearing set for December 11th. That's what but he's not out on bond. With that in mind, Your Honor, if I can confirm his comp hearing on another case for December 11th, would you consider RORing him?
Who are you talking about?
Quentin James. I didn't see his. Sorry.
James is here. We don't have no add-on bond for him.
No, because he's been found incompetent. We don't place FADs for those. If they've been found incompetent, they don't get held.
Yeah, I don't have an out on bond.
They don't get held for them.
Okay. So with that in mind, because would you consider RORing him on this new case, Your Honor, seeing as he's been held incompetent, or I believe he has a competency status here on his other case?
No, I won't.
Okay.
May I please have your name?
Kevin Michael Walker Jr.
Who?
This is an
Arraignment.
Arraignment, Your Honor. And what's his name?
Walker.
You don't have Kevin Walker over here? Daddy Jimmy Walker?
No, I don't have a walker.
He's a traffic arraignment.
I've got. All right, Mr. Walker. So this is an arraignment on driving while license suspended with knowledge. The public defender has already been assigned to represent you. Let me pull up your case. There's no driving record attached, so I can't look at it.
Your Honor, I didn't make an offer as there is a violation of probation that's pending.
Yes, Your Honor. We would just ask that we just want to enter a plea of not guilty and schedule for pretrial.
All right, we'll set you for, enter a plea of not guilty and set you for a pretrial conference.
Pretrial conference be heard in Division 82, January 22nd at 8:30, courtroom 4F.
I just want to confirm that we're appointed onto this new case. I know we were appointed on to other
Yeah,
cases.
you were appointed on this one.
We were?
Yes.
Okay.
Sorry if I sound.
May I please have your name, sir? All right, Mr. Arroyo, this is your arraignment. You've been charged with petty theft of $100 or more. The public defender has already been assigned to represent you, and you have been charged by information. Counsel?
Your Honor, there was an offer conveyed to Mr. Arroyo on both of his cases. Now, I'd called his name when he was back there, and he hadn't responded. Can I ask how much credit he's received, Madam Clerk? So, 40 days. You understand you understand me? Now, Your Honor, I briefly conveyed to Mr. Arroyo the conditions of his release with the offer. Now, would you, could we reset him so we could just have a moment to review the rights that he'd be giving up? I believe he wants to go forward with it, Your Honor, unless you'd feel more unless you're okay with going through those rights right now.
No, if he needs an opportunity to make a knowing plea agreement, we'll certainly give him the time that he requires.
Just go ahead and review this. We'll bring you back. Thank you, Your Honor.
Yep, we'll call him back up. Have a seat and read and let him know when you're ready.
Mr. Barr, just so the clerk knows, is he going to be pleading for both of the cases? He's going to be closing both cases?
Yes, I thought it was a dual offer, 60 days. They were going to run concurrent.
That's fine.
And you did advise him of the collateral consequences, right, since that'll be 2 petty thefts?
Just to confirm.
Is there going to be adjudications on both?
Yes, Your Honor.
Yeah, so next act of petty theft can be charged as a felony. You told him that? He's aware?
To be honest, Your Honor, I just when clients don't call initially,
He wasn't up here initially when he went back there.
he wasn't. Okay, all right. I just feel that I should convey it to them, but that is something I should mention to them, Your Honor.
I'm sorry.
All right, the clerk had to step out for just a moment, so All right, Mr. Arroyo, did you have the opportunity to read that over?
Yes.
Okay. I'm reviewing the arrest affidavits now for a factual basis. All right, Mr. Arroyo, I have the plea agreement form. Are you under the influence today of any drugs, alcohol, or medication that would impair your thinking?
No. No, Your Honor.
Is anyone forcing you to enter into these plea agreements today?
No, Your Honor.
Do you understand that if you are not a United States citizen, entering into these plea agreements will subject you to deportation?
Yes, Your Honor. I'm Puerto Rican.
Are you currently on probation for any other offense?
No.
All right, and I do have to advise you, you are entering pleas to 2 counts of petty theft. It's an adjudication of guilt on both of them. If you commit another act of petty theft, the state of Florida can charge you with a felony. Do you understand that?
Yes, I understand.
All right, so I have reviewed both arrest affidavits, and I do find a factual basis for the plea. On each count of petty theft in the 2 cases, how do you plead? I'll accept your plea of no contest. I'm going to adjudicate you guilty on both cases. We'll address 2025 MM 409-675 AO first. I'm going to sentence you to 60 days in the Orange County Jail and give you credit for time served of 40 days. I'm going to assess mandatory court costs and cost of prosecution and require that you not return to the Walgreens located at 2300 South Goldenrod Road. With respect to the financial obligations, I'm going to give you 1 year to pay that off. On the other case, I'm going to sentence you to 60 days in the Orange County Jail and give you credit for time served of 40 days. The sentences are to run concurrently. I'm going to require that you not return to the famous footwear located at 6653 Eagle Run. I'm going to assess mandatory court cost and cost of prosecution, as well as cost of investigation of $193.15 to the Orlando Police Department, and order you to pay restitution of $151.98. The state attorney's office to provide the court a restitution order within 5 days. And Mr. Arroyo, understand that any financial obligations that you pay to the clerk of the court will first go to the satisfy the restitution to famous footwear, and then it will be applied to your costs. Anything else, defense?
No, Your Honor.
Anything else, state?
No, Your Honor.
All right, sir, please follow the officer out the blue door to be fingerprinted.
The next person, Judge, is this person right here for the pound attorney. He's in felony.
May I please have your name?
Caleb Robinson on behalf of Mr. Gordon.
Okay, defendant, may I please have your name?
Gordon O'Neill Grandis. Grandison, I'm sorry.
All right, Mr. Grandison, you've been charged with trafficking in fentanyl and possession of cannabis less than 20 grams. All right, it was field tested and weighed, so there is probable cause. And then the trafficking in fentanyl is state.
Your Honor, as probable cause has been found, state is requesting that defendant be held no bond pursuant to 907.0415D, as that is an enumerated dangerous offense.
All right, and is it the state's intent to file
Yes, Your Honor, we will be filing the pretrial detention motion. If the clerk could give us a pretrial detention hearing.
Defense counsel, you want to be heard?
Yes, Your Honor. The stay is not already filed. The statute enumerates that the motion for pretrial detention needs to be filed prior to the initial appearance for detention to be held. That being said, this is not a PBL case, so it's not otherwise aside from the new statute in regards to the pretrial detention, something that he would be eligible to be held without bond. So prior to the filing of that motion for pretrial detention, he should be eligible for a bond today. That being said, I also have information regarding to Mr. Grandison in that he does have some heart failure issues that are immediate medical problems. He has lived in the same house for his entire adult life. He lives in Central Orlando, Florida. He has several dependents that he cares for. I do think given the facts and the lack of the filing of the pretrial detention motion, Mr. Grandison should be granted a reasonable bond in this case.
All right, I deny that request. I am going to hold the defendant without bond on count 1, the trafficking. Count 2, I will stay the bond at 1,000. State, I'm giving you 72 hours to file the pretrial detention motion, and the case will be set for a pretrial detention hearing on?
In Division 18th on December the 5th at 9 a.m., courtroom 7B.
Is it the 5th?
The 5th, yes.
Thank you.
Thank you, Your Honor. That's all I have. May I be excused?
You may. I have Michael Canto.
Your Honor, could we have him reset? He does have a plea. I'd like to convey it to him.
I will roll till tomorrow. May I please have your name? All right, Ms. Payton, you've been charged with petty theft, and I don't have, did you want to see if you qualify for a public defender? Or were you going to get private counsel? All right, please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth?
Yes.
All right, thank you. You may put your hand down. Do you have a regular source of income, ma'am?
Yes.
How much and how often?
It varies, like weekly, $500 or $600.
Do you have any dependents?
No.
All right, you do qualify for a public defender. I'll appoint the Office of the Public Defender to represent you. I do find probable cause, and I'll stay the bond at $500.
Your Honor, Ms. Payton's actually been conveyed an offer as adjudication, credit time served, no return to the Publix on 400 East Central Boulevard. It's for her first petty theft. She wanted to go through with this offer. I just need her signature.
All right, then I won't appoint the PD then.
I didn't want to interrupt you, Your Honor.
If it's going to be a plea, you can.
Okay.
Thank you. All right, Ms. Payton, are you under the influence today of any drugs, alcohol, or medication that would impair your thinking? No. Is anyone forcing you to enter into this plea agreement?
No.
Do you understand that if you're not a United States citizen, entering into this plea agreement will subject you to deportation?
Yes.
Are you currently on probation for any other offense? All right, and I do have to advise you that petty theft is an enhanceable offense. If you receive 2 convictions for a petty theft and commit another act of petty theft, the state of Florida can charge it as a felony. All right, as to the charge of petty theft, how do you plead?
No contest.
I'm going to accept your plea of no contest. I'm going to adjudicate you guilty. I'm going to give you credit for time served. I'm going to order that you not return to the Publix located at 400 East Central Boulevard. I'm going to assess mandatory court cost and cost of prosecution. With respect to the financial obligations, I'll give you 1 year to pay that off or report to the clerk of the court to set up a payment plan.
Okay.
All right, may I please have your name? All right, and you did not fill, is this going to be a plea or no?
She had a plea conveyed to her. She doesn't want to go through with it, Your Honor. We'd ask for an appointment.
All right, you did not fill out the form. Did you want to see if you qualify for a public defender?
Sure.
All right, please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth?
Yes.
All right, you may put your hand down. Do you have any income?
No.
No? All right, I do find that you qualify for a public defender. I'll appoint the office of the public defender to represent you. You've been charged with petty theft and possession of drug paraphernalia. I have reviewed the arrest affidavit. I do find probable cause. I'll stay the bonds. Count 1, 500. Count 2, 500. Please follow the officer out the blue door.
No return, Your Honor.
Oh, and no return to the scene. Thank you. All right, sir, may I please have your name?
Robert Albert Steele.
All right, Mr. Steele, are we going to resolve this case today? You've been charged with state misdemeanors, the paraphernalia.
There's an adjudication credit time served, Your Honor.
Yes, Your Honor. I just need a signature. There we go.
Thank you. Mr. Steele, are you under the influence today of any drugs, alcohol, or medication that would impair your thinking? Anybody forcing you to enter into this plea agreement today? Do you understand that if you're not a United States citizen, entering into this plea agreement will subject you to deportation? Are you currently on probation for any other offense? On the charge of state misdemeanors, how do you plead?
No contest.
I'll accept your plea of no contest. I'm going to adjudicate you guilty. I'm going to give you credit for time served. Mr. Baj, your client transient?
I believe so. He is transient, Your Honor.
All right, I'll assess mandatory court cost of prosecution, reduce it to a civil judgment.
Thank you very much, Your Honor.
May I please have your name?
Stephen Summers.
All right, Mr. Summers, you've been charged with open container. Are we resolving your case today?
Yes, Your Honors. Sign right there. An offer is conveyed to Mr. Summer, adjudication of guilt, credit time served.
All right, Mr. Summers, are you under the influence today of any drugs, alcohol, or medication that would impair your thinking?
No.
Anybody forcing you to do this, sir?
No.
Do you understand that if you're not a United States citizen, entering into this plea agreement will subject you to deportation?
Yes.
Are you currently on probation for any other offense?
No.
On the charge of open container, how do you plead?
No contest.
I'll accept your plea of no contest. I'm going to adjudicate you guilty. I'm going to give you credit for time served. I'm going to assess mandatory court cost and cost of prosecution, which I'll reduce to a civil judgment.
Thank you.
2 days. I do a civil judgment on this one too. Oh my God, I should have been ready.
May I please have your name?
Cynthia. Ready.
All right, Ms. Barco, you've been charged with violating your business purposes only license. Can anybody help me on this out on bond sheet? I can't find this misdemeanor. I find,
It's a CT case, actually, Your Honor. It's 2025, it should be 2025 CT 302430 AE.
okay, I did find that one.
Yeah, they listed the case number incorrectly.
All right, so, ma'am, you are currently out on bond for driving under the influence. I'm going to revoke that and set it at none, since you have another driving offense in order to protect the traveling public.
So it's CT.
I'll appoint the officer of the public defender. Please follow the officer out the blue door.
Your Honor, if I could just be heard briefly, would the...
No, you may not. There's no way on a DUI with a driving violation, absolutely not.
And
Follow the
Your
officer
Honor,
out the blue door.
on the new law, you stayed the bond at 500?
Yes, thank you.
Ma'am.
So this is the case number right here.
Yes, that she's out on bond on. Yes. Please step forward and tell me your name.
Jamal Claxton.
I have Gavin Cambry next. Thank you. All right, Mr. Claxton. All right, and you've been charged with driving while license suspended. But hold on, I gotta see, the judge who was assigned to your case sent me a message. I gotta see. All right, so you failed to appear at arraignment and you were out on bond, but the court D6 and closed the case instead of issuing a capias. So with respect to the new law violation, I'll find probable cause, I'll appoint the office of the public defender, I'll stay the bond at 500. On the attaching tag, out on bond, I'll take no action. On the driving while license suspended, 2025 CT 3020788 AE, I'm going to revoke the bond and set it none.
So we would, you can't bond out. No. Your Honor, would you consider revoking that bond and setting a higher bond on that, Your Honor? On the
Well, your client had a driving while license suspended charge, and he was out on bond, failed to appear at arraignment, got another driving violation, so no, I would not consider that at this time.
I can't say nothing to that.
she's made up.
I mean, I never got any notice. I called them for 45 days.
May I please have your name?
Charles Cotton.
All right, Mr. Cotton, you've been charged with driving while license suspended. There is probable cause. I'll appoint the office of the public defender and stay the bond at 500. May I please have your name?
Asa Baker.
I have Kyle Richardson. Bonded. Tell me your name one more time, sorry.
Asa Baker.
All right, Mr. Baker, this is a failure to appear, and the judge in your case did set bond at 1,000. Do we know if the PD's already been appointed? It's from 2023. No? Private?
No, nothing, no PD.
No PD, no nothing? All right, Mr. Baker, I'll appoint the Office of the Public Defender to represent you.
Yeah.
May I please have your name, sir?
D'Arlo Brown.
All right, Mr. Brown, this is a failure to appear warrant. The judge in your case did set bond at none. And then you also have a new case of resisting an officer without violence. On the new case, I'll appoint the Office of the Public Defender to represent you, and I'll stay the bond at 500. Let me just double check and make sure that your case, that you already have the PD on your other case.
Tracy Keegan
Oh, you have private counsel
on that one.
on your felony case. Are you gonna keep Ms. Keegan? Yep, okay.
Have you notified her?
I was actually at court when I got the FTA, so they just told me that
She didn't know if the judge was gonna, I had court at 1:30, I got there at 1:36.
Okay, all right, talk to Ms. Keegan about it. She'll get it straightened out for you.
Okay, no. I'm gonna,
But you did point to PD on his other case.
On
correct?
on the resisting, yes.
That's what I count.
May I please have your name, sir?
Elgin Crawford.
All right, Mr. Crawford, you've been charged of driving while licensed revoked as an habitual traffic offender. I'll appoint the Office of the Public Defender to represent you, and I'll stay the bond at $2,500, fine PC.
Your Honor, would the court consider reducing the bond for my client?
Why?
Your Honor, my client relates to me that he hasn't, from what it appears like, he hasn't received a. No, Your Honor. I was going to make a statement on the behalf. We would just consider it for the financial situation of my client.
All right, please follow the officer out the blue door. May I please have your name? All right, Mr. Gallup, you've been charged with possession of cocaine, possession of burglary tools, petty theft, 1 prior conviction, and possession of drug paraphernalia. Mr. Ball, you wanted to be heard on the tools?
Yes, Your Honor, just briefly. From the affidavit, the justification for the burglary tools was that the defendant had bolt cutters. If I could have a minute to. The defendant had bolt cutters, and when I looked at the statute, it's necessary for those, for the burglary tools to be possessed with the intention of committing that burglary. From what it appears, it doesn't seem like anything that he had taken, Your Honor, would have required those bolt cutters. My client had a number of things on him that evening. I think the officer decided, based on the fact that in the past, bolt cutters may, or based on his experience, bolt cutters may have been used for burglary. That was what my client was using it for, but I don't believe there's any evidence to suggest that he came in with the intention of using those. I think, for the most part, Your Honor, it was a grab-and-go situation if the affidavit is to be believed. So for that reason, we don't believe there's probable cause for the burglary tools.
Mr. Eugene?
The state has no argument, Your Honor.
All right. So with respect to count 1, I'll find probable cause. I'll stay the bond at $2,500. Count 2, I won't find probable cause, or I'll ROR the defendant on count 2. Count 3, I'll stay the bond at $500. Count 4, I'll find PC and stay the bond at $500. And I'll appoint the Office of the Public Defender if I hadn't said that previously.
No return, Your Honor?
I'm sorry, what? Oh, and no return to the Walmart.
Thank you. That's your bond total.
May I please have your name?
Justin Gandy.
All right, Mr. Gandy, you've been charged with petty theft, 2 prior theft convictions, resisting a merchant, trespass, and structure. Here's a warrant signed by a judge, so probable cause was previously found. The judge did set bond, and I'll stay those. Count 1, $1,500. Count 2, $500. Count 3, $250. The additional conditions of release are no contact with the victim or witnesses, and no return to the Dollar General store. I will appoint the Office of the Public Defender. And with respect to your out on bond case, I'll revoke the bond and set it at none.
Briefly, Your Honor, can I get the bond amount on his new law cases?
Yes. Count 1 was $1,500. Count 2 was $500. Count 3 was $250.
And just briefly, on the out on bond case, which you revoked and set at none, Your Honor, would the court consider setting a bond on that? He was ROR'd on that. He spent 33 days in jail, I believe. Due to that, he spent 33 days. We would just ask if you would set a bond, and if he can afford it, Your Honor, I feel like that'd be incentive to no longer pick up any cases going forward.
Ms. Eugene?
Your Honor, the defendant was ROR'd on November 15th, and the new law offense happened on November 21st. So less than a week within his release, he was back out stealing. State would ask that you revoke and hold him at no bond.
I'm gonna keep it at no bond on the out on bond. All right, may I please have your name?
Trivia Godwin.
All right, Ms. Godwin, you've been charged with criminal mischief and aggravated assault with a firearm. I'll appoint the Office of the Public Defender. I did review the arrest affidavit. There is probable cause. That's a third-degree felony, right? The ag assault?
Yes, Your Honor.
So there is bond. State, do you have a recommendation?
Usually it's $5,000, Your Honor.
All right, on count one, I'll stay the bond at 1,000. Count two, I'll set bond in the amount of $5,000. I'm going to order that you have no contact with any victim or witness, that you not possess any weapons or firearms. If you have any that were not already confiscated, you must turn them in to the Orange County Sheriff's Office within 4 hours of release from incarceration. I'm going to order that you not return to that Greyhound station. It was 555 North John Young Parkway. Anything else, State?
Nothing from the state, thank you.
Anything else, Defense? All right, please follow the officer out the blue door. May I please, Hollenden?
He refused his appearance, Your Honor.
We'd ask to waive that appearance, Your Honor.
All right, I'll appoint the Office of the Public Defender. It is a, okay, so it is a violation of conditional pretrial release, and the judge in the case did set bond at none. All right, may I please have your name?
Terry Holt.
Mr. Holt, you've been charged with possession of cocaine and possession of drug paraphernalia. And that is the arrest affidavit. I'll appoint the Office of the Public Defender. With respect to the arrest affidavit case, I'll find probable cause and I'll stay the bonds. Count one was $2,500, count two was $500. There's also a warrant signed by a judge for possession of substituted cathinones. And so the judge found probable cause previously and set a bond in the amount of $2,500. I'll also appoint the public defender on that case. And the judge had further conditions of release that you not possess or consume any alcohol, illegal drugs, or controlled substances without a valid prescription. Bless you.
Thank you. State is requesting that 25 CF 15686, currently in Division 22, be transferred to Division 16, where there is a lowercase number pending.
Yes, I'll grant that request.
May I approach?
You may. Thank you. Joanne Dines? Joan?
On behavior standards, Your Honor.
We'd ask to waive that appearance, Your Honor.
All right, I'll appoint the Office of the Public Defender, and this is, it came in as no bond. It's possession of a controlled substance with a weapon. Is that a bondable offense?
Yes, Your Honor.
What is that? What degree felony is that one?
One moment. F2.
All right, I'll set bond in the amount of $10,000. I'll order the defendant not to possess any weapons or firearms. If he has any, must turn them into the Orange County Sheriff's Office within 4 hours of release. And it was just an arrest, so there's not a location. Okay. May I please have your name? Who's up next? Keaton? May I please have your name?
Jamaica Keaton.
All right, Ms. Keaton, you've been charged with criminal mischief and resisting an officer without violence.
With
Violence, sorry. You do qualify for a public defender. I'll appoint the Office of the Public Defender to represent you. With respect to count 1, I'll stay the bond at $2,500. Let me just look at you do have a previous conviction of Bat Leo. All right, with respect to the resisting officer with violence, I'll set bond in the amount of $5,000.
Your Honor, my client would like to ask the court if the court would consider RORing her. She brings up some circumstances where she needs to take care of family members in her life. But it seems like she's fully employed in the community. She clearly has ties to the community based on what she represented to me. So she'd like to ask the court to ROR.
Any argument? Let me see that arrest affidavit again.
State would object, Your Honor, due to the nature of the offense. This was something that was premeditated, as she traveled to the area and she damaged the vehicle with a bat, Your Honor. So state has no objection if the court wants to reduce it, but ROR, state would object.
So the allegations in the arrest affidavit are that your client traveled to a location and began hitting another car with the baseball bat. And then threatening the victim. Yeah. And then when the police arrived, he was kicking the door, caused the door to strike the officer's leg. The back windshield was completely broken out. The mirrors and the parties, looks like we got the mother of the children and a new female involved. I'm not gonna ROR the defendant. I'll reduce the bonds. I'll do count 1, 1,000, and count 2, 2,500.
Thank you very much, Your Honor. Your Honor, for my next client, can we please waive the reading of the charges?
Yes, I have La Pena next, though.
On it, Your Honor.
Thank you. All right, Mr. Lindsay, You're Mr. Lindsay, correct?
Yes, Your Honor.
All right, and you did not, Mr. Lindsay, you did not fill out the form. Did you want to be represented by the Office of the Public Defender?
Yes, ma'am.
All right, please raise your right hand. Do you swear affirm testimony you're about to give is the truth?
Yes, ma'am.
All right, do you currently have any income?
No, ma'am.
All right, you may put your hand down. I'll find that you qualify for a public defender. I'll appoint the Office of the Public Defender to represent you. All right, I'll set bond in the amount, I'll find probable cause, I'll set bond in the amount of $2,500 and require that you comply with all reporting requirements within 24 business hours of your release from incarceration. Thank you. Please follow the officer out the blue door. Please step forward and tell me your name.
Blanca Palacio.
I have McCroy.
Dario Santiago, he bonded, Your Honor.
Oh, that's somebody else. Yeah, McCroy.
Do you have a book?
503-8087. Oh, that is Santiago.
McCroy bonded.
All right, tell me your name one more time.
Blanca Palacio.
All right, Miss Palacio, we got a few things going on here. First of all, you do qualify for a public defender, so we'll appoint the Office of the Public Defender to represent you. The first case that we're going to take is the 2025 CF 15647. This is a warrant signed by a judge, so probable cause was previously found. On the charge of petty theft, the judge did set bond in the amount of $2,500. And we'll order no return. Then we've got another case, a violation of probation. It's on view, or it's an actual, it's on view for Osceola County? All right, so on those, we just gotta tell Osceola, so those, it's on view violation of probation, so bond is none, but we'll let Osceola County know that you're here, and they'll have 24 hours to pick you up. May I please have your name?
Dennis Pugh.
All right, Mr. Pugh, you've been charged, this is a warrant, so a judge previously found probable cause for driving while licensed, revoked as an habitual traffic offender, or habitual offender. The judge set bond in the amount of $1,500. I'll stay the bond and appoint the public defender.
Thank you.
May I please have your name?
Juan Reyes.
Mr. Reyes, you've been charged with possession of cocaine and possession of drug paraphernalia. I'll appoint the Office of the Public Defender. I'll find probable cause. I'll stay the bonds. Count 1, $2,500. Count 2, $500. Please follow the officer out the blue door. Please tell me your name, sir.
Jalen Richardson.
All right, Mr. Richardson, you've been charged with possession of cannabis, more than 20 grams, possession of drug paraphernalia. All right, I'll find probable cause. I'll appoint the Office of the Public Defender to represent you. I'll stay the bonds. Count 1, $2,500. Count 2, $1,000. And you're out on bond on a driving case in Osceola County. I'll revoke the bond and double it.
And what's that? What's that?
4,000.
Would be 4,000 total, Your Honor?
$4,000 on the Osceola case, and then the bonds on the new law.
It would, sorry, I may have missed this, Your Honor, I apologize. He said 4,000 with the out of, I'm having a difficult time.
No, the $4,000 is out on bond. I revoked and doubled.
Okay, thank you.
And then the new charges, do you need me to repeat those, Mr. Ball? Okay.
Your Honor, thank you.
And the next defendant qualifies for PTR.
May I please have your name, sir?
My name is Travis Robinson.
All right, Mr. Robinson, you've been charged with possession of tetrahydrocannabinoids, and I'll appoint the Office of the Public Defender. You do qualify for PTR. Mr. Baugh, did you have the opportunity to discuss PTR with your client yet?
Well, I actually gave him a separate advisement than the one I normally do. I'd like to briefly give him another one. Like the PTR, Your Honor.
All right, so Mr. Robinson, I'll release you on pretrial relief, no conditions, PTR.
Thank you.
No conditions, okay, thank you, Your Honor.
May I please have your name?
Javier Robles Lopez.
Mr. Robles, you've been charged with possession of fentanyl and possession of cocaine. I'll appoint the Office of the Public Defender to represent you. Both of them were field tested, so I'll find probable cause. On count one, I'll set bond in the amount of $2,500. And count two, I'll set bond in the amount of $250.
250, thank you, Your Honor.
May I please have your name?
Jamal Rudolph.
All right, Mr. Rudolph, you do qualify for a public defender, so I'll appoint the Office of the Public Defender to represent you. Let's see here. You were charged with trafficking in methamphetamines, trafficking in 14 grams or more of fentanyl, trafficking in another count of trafficking in methamphetamines, possession of cocaine, possession of cannabis less than 20 grams, and resisting an officer without violence. Ms. Eugene?
I'll start without, regardless of probable cause or not, Your Honor. With regard to count one, it's trafficking in meth over 200 grams. It is the same statute, Your Honor, but instead of it being -11, it should be -24, and that gives the 14 grams. So it is appropriate to still do the trafficking. It just, the probable cause could be found for the 14 grams as opposed to the 200. With regard to count three, Your Honor, which is another trafficking in meth over 200 grams, there were two separate amounts. One was 11 grams and then one was 111 grams. I don't know if the court wanted to combine the two. It's still going to be the trafficking, but if the court was going to just hold it as separate, two separate amounts, it would be 893.13 sub 6 sub A, which is just the possession of meth, Your Honor. And then, of course, with regard to count two, if the court is finding probable cause, state would be asking for defendant to be held no bond.
And it's your intent to file, if I find probably it's your intent to file a pretrial detention motion?
Yes, Your Honor, and
and
state would ask for the pretrial detention hearing.
Mr. Baugh, do you want to be heard on anything?
Your Honor, if it's pursuant to the statute, we would just ask for the hearing. I have no argument besides the fact that we would ask for a hearing, Your Honor.
All Right, and then what about, since it's all one stop, I know there's 2 separate baggies of the methamphetamine. So is it not appropriate to combine those 2? Or since there's 2 baggies, it's usually charged as 2 separate?
It really does depend, Your Honor, and it's really at the court's discretion. If you want to combine the 2, then you would ROR one of the counts and treat the other as the trafficking.
Okay, and so if I combine the 2, so that's 111.2 and 11.2, so that's 0.4, so that's 122.4 grams, so it's still trafficking.
Yes.
And you said that should be 893.135 sub 1 sub F sub 1 dash 24?
Yes, Your Honor.
Okay. All right, so on count 1, we'll combine the quantities of the methamphetamine, and I will find probable cause for trafficking at the 122.4 grams. I'll stay the bond at $250,000. The trafficking in fentanyl, now that one's only 12.5.
But to be trafficking, it only requires 4 grams.
Oh, only 4, okay. All right, so I'll find a probable cause for the trafficking in the fentanyl, and we'll hold the defendant no bond. I'll give the state 72 hours to file a pre-trial detention motion in accordance with their statement that they will. We'll set it for a pre-trial detention hearing on
December the 5th at 9 a.m., courtroom 7B.
On count 3, I'll ROR. Count 4, $1,000. Count 5, $250. Count 6, $250.
Your Honor, what,
So no
You
PC to count 3? Yes.
Well, Your Honor, it's not that there's no PC. Could you say that there is PC, but it is duplicative and therefore that's why you're doing the ROR?
Yes.
Because the drugs are there.
Right. So on count 3, I do find it duplicative as I combined the 2 weights for count 1. So it's not that there's no PC, it's just that I'm RORing it because it is a duplicate charge. All right, please follow the officer out the blue door.
usual. December 5th, correct, Your Honor? The pretrial?
Correct.
Thank you.
All right, Mr. Ward?
He's mental health, Your Honor.
The what? The what?
Mental health.
Mental health. All right, we'll reset within 24 hours of his return from the mental health.
It's not, that's when they're in the hospital.
Oh, that's in the hospital. This is
When they have
different.
things coming, we can waive them.
Oh, they're not coming. Okay. All right.
We'd ask to waive the appearance.
All right, I'll appoint the Office of the Public Defender. We'll waive the appearance. So, oh, well, he's out on bond for the same resisting. So do you want to bring him back so I can tell him I'm revoking his bond and setting it at none?
Even if I told you that it hasn't been filed on yet, Your Honor?
Oh, it hasn't been filed on?
It's not.
But it just happened, 11/10. He's got a resisting without violence, and now he's resisting again,
Female.
this time with violence.
Would you,
She.
okay, would you consider revoking and setting a bond instead?
Well, we're escalating. Do you have any concerns of competency?
I didn't.
Let's just roll the defendant and let me see the defendant and get a understanding for what we're dealing with.
Okay, thank you.
If you don't come, okay, we're just gonna reset it for tomorrow.
All right, we're off the record.
They can't come tomorrow.
Bikini Bottom, there's a new driver on the road, and his name is...
John C.
God damn it!
And I stay under you fighting, plus I'm storming on you chumps like I'm thunder and lightning. Ain't no way you breaking me, kid. I'm harder than nails, plus I keep it on lock like I'm part of the jail. I'm slaughtering stairs.
Say his name and